Welcome to Litigation and Capital.
Hey everyone, welcome into an all-new episode of Litigation and Capital with Stephen Mirsky. I am your host, Mike Leon. Stephen is the founder of Mirsky Corporate Advisors, and in each episode, we've been breaking down the high-stakes legal issues that affect companies like yours, those earning 10 to 100 million a year, so you can turn the complexity into leverage and protect what you've built. Today's episode, we're going to talk about how the same contract or lawsuit can play out very differently depending upon which state's laws applies, and why jurisdiction and choice of law clauses decide far more than the executives realize. Stephen, it's good to see you as always. Let's dive into the minutia of this, because this is what I love about you. You get to explain some of this stuff. So how does the courts distinguish between the two things I just mentioned, the jurisdiction and choice of law? What are those, and why are they often confused in these business contracts?
Thanks, Mike. It's great to be here. Great talking to you again. So let's break it down. Choice of law, jurisdiction, what are they, right? Jurisdiction is where are we battling, right? In what state, in what court? Are we doing it in federal court? Are we doing it in state court? Are we doing it in arbitration? These are things that are important that are laid out in the contract. The other thing is choice of law. Which rule book are we going to apply? Is it going to be California? Is it going to be New York? Is it going to be UK? We don't know, right? And contracts often just specify whatever's most favorable for the drafter. And as a transactional lawyer, prior to litigating these cases, when I was a transactional lawyer, most of these are throwaways. Like, yeah, we'll never go to court over this. But when you're litigating, these have real practical consequences on both the procedural posture of your case, the remedies that you may have, and other matters.
So in that scenario, when a contract designates one state's law, let's just say, but another court has already heard the case, starting to hear the case, how do the judges decide which state's law is going to apply?
You're not going to like this answer, but it's penny, right? So let's use California, just ground it here a little bit. Sometimes, or California analysis intertwines choice of law and venue a little bit, because California wants to protect its constituents against unfair business practices that violate statutory public policy, right? So California is very grabby, it's very hands-on. Florida, for instance, says, hey, look, if you state in your contract that New York law applies, we're just going to apply New York law. It doesn't matter to us. You had the freedom to negotiate. So part of it is, where are you going? And then in determining, from the outset which law applies, generally speaking, the court's going to apply the default rules of that state, right? So if you file a lawsuit in California, California's going to interpret it through California law. If you want to do something different, then you're going to have to file a motion or make some sort of argument to have another law apply.
Stephen, can I ask you to break down this Restatement 187? Like, kind of what is that? What factors within that create a substantial relationship that's sufficient for enforcing the state's law?
Section 187 of the Restatement is a guidepost for the courts. And what it does is it says, hey, look, I have law A and I have law B. Which law applies? How do I, as a court, make a determination to do this? And many courts have adopted this framework to ground their decision making. California has done that specifically in Ned Lloyd Lyons BVV Superior Court, where it said, yeah, we adopt 187 too. And there's a three-part test. The first part is, is there a real connection or reasonable basis between the parties and the choice of law? And then there's a secondary question, is there a conflict between a fundamental policy of the foreign state and the law of the chosen state? If the answer is no, then the court's free to determine, to just apply the choice of law that was in the contract. But if the answer is yes, there's a third question. Does the forum or the interested state have a materially greater interest in the outcome than the other state? And then if the answer is yes to that, a court in California, for instance, will then apply California law over the law that was chosen in the contract.
Yeah.
And so, what is a reasonable basis to a jurisdiction? Well, courts often look at where you're located, right? Are you I don't know, a Delaware corporation operating in Delaware? If the answer is yes, well, then there's a reasonable connection to Delaware law. But if you are a Connecticut limited liability company trying to apply Wyoming law, the court would likely, and the defendant is a California company, the court's likely to say no, right? And so that's one of the ways that a court will view this in applying the test.
Are there any like public policy exceptions that kind of limit the enforcement of an out of state choice of law clause?
Yeah, so a court is not going to let you get around public policy, right? I'm not going to be able to enforce something under, let's say, New York law that would be unenforceable under California law. So a court's going to take a close eye to that. The issue is that you have to find a fundamental policy. So what is a fundamental policy? A fundamental policy is something that's typically a violation of a statute, right? So we have instances of usury. We have anti-waiver provisions. We have, in California, for instance, Business and Profession Code 16600, which prevents people from entering into non-competes. And then there's other public policy mechanisms that protect consumers' rights from being dragged into another state. So the issue is, is there some fundamental statutory policy that this lawsuit or this contract is trying to draft around? And if the answer is yes, then the court's going to take a closer look at this and say, I'm going to keep it here.
Let's just take two states in isolation. It could be any two, New York and Utah, right? Red and blue. Are there any two contrasting jurisdictions, right, that we look at? What are some of the practical differences that exist when it comes to actually enforcing the commercial contracts or usury laws, like you mentioned?
When we choose law, and it's saying what rule book applies, and some rule books are very strict and some are a little bit more flexible, and so that's where you're going to look at where we want to attack and what we want to enforce. As we say in New York, usury is a public policy, right? They have a very strong interest in preventing usury, but there's a lot of carve-outs that prevent it from being enforced. Similarly, in Utah, there's a strong public policy against usury, but I'm going from memory. I believe the court there said usury isn't a very strong public policy. It's something that we want to avoid, but it's not going to override something from another state. And so that's where having a court interpretation of what usury is and how important it is to that state's interest has a practical effect on choice of law.
Can you break down a little bit for our audience about forum selection clauses and how that kind of brushes up against like personal jurisdiction rules? What is all of that, Stephen? When can a party challenge them when they're unreasonable?
You should always challenge them. Make the other party prove it works, right? If you're on the other side, if you are on the receiving end of a lawsuit, right, you want to defend against everything. Start with procedure. So what is jurisdiction? Jurisdiction means, does this court have authority over me? And if I'm a defendant, I'm going to say, no, it doesn't, right? So how do I prove that? And we're going to look at a variety of things. Under the Supreme Court has said you have to look at whether activities are purposely directed or whether or not a defendant has purposely availed themselves to a forum. There's a very interesting analytical framework that goes beneath that, but bottom line is the court is looking for some reason to connect your actions to this state. So, for instance, let's say I'm a California corporation and you are a Nevada company, but the Nevada company is suing me in Florida. Well, why does the Florida court have jurisdiction over me in California? I didn't do anything in Florida. I didn't, harm anybody there. I didn't seek any benefit of Florida laws there. So why am I in Florida? Court, you can't hear this. And the court will go, yeah, you're probably right. In federal court, jurisdiction is even more important because statutorily or constitutionally, they're courts of limited jurisdiction, meaning you can only do certain things in federal court. And so in federal court, you have to look at is the issue a federal question? Meaning, does the cause of action arise under some statute that's protected by the United States Code? Or is there diversity jurisdiction? Meaning, are the parties of completely diverse? They're citizens of separate states, and whether the amount in controversy in the complaint is it over $75,000. If the answer is no to any of those questions, there's no federal statute and there's no diversity or no amount of controversy greater than $75,000, the court's going to say, sorry, I can't hear this case. So these are some of the considerations that you have at the very beginning of where do I file, how do I file, and where do I go? So let's tie that back to forum selection clauses. Well, forum selection clause is, again, usually a contractual right. And it'll say, hey, look, if we get into a fight, we're going to hear it in state X, wherever that may be. And typically you're going to say, oh, we're going to waive any defenses to inconvenient forum or lack of personal jurisdiction because the parties are contractually agreeing to a certain place. Now, does that mean by itself that a forum selection clause is 100% enforceable? The answer is generally yes, it is, but there are a few exceptions. The Supreme Court has come out with rulings in the last 20 years or so that say, hey, look, the parties have a freedom to contract. If they're going to negotiate this, then we're going to enforce it. And, then there's a little carve out. And the carve out is, oh, well, unless the forum selection clause itself was procured by fraud or duress, et cetera, which is really hard to do. So if the contract was good, but the deal is bad, it's hard to say that this clause in particular was procured by fraud. California has a different analysis, though. California looks at it, they blend the choice of law and choice of forum issues together. And this case is called Verdugo v. Alliant Group LP. And in this case, the court says, well, does the choice of forum violate some fundamental policy of California? And if the answer is yes, then we're going to keep it here because we like to protect our people. And so I guess long story short, to try to land this plane, there's a lot that goes on with jurisdiction, and it's something that needs to be closely analyzed at the outset of any case.
Well, there's a lot to it. I wanted to ask you because we're talking about domestic, but we haven't even talked about foreign, like in cross-border transactions. Like, how do the courts kind of treat contracts that reference both U.S. and foreign law? Like, what forum prevails there?
It's a mixed bag, right? Same principles apply, right? The United States is going to apply, or the state is going to apply the same law to its contract. So it's going to look at, let's say, Hong Kong law, for instance, and then look at California law and say, hey, is there a material difference in the outcomes here? Oh, no, we're going to go send it over there. The issue when you get to cross-border transactions is, let's say you're a company and you're trying to sue somebody on the other end. The issue becomes service and jurisdiction. There's something called the Hague Convention. The Hague Convention is a treaty between all these different countries that says, hey, look, this is how you can serve us. And some are really easy. I can just mail somebody and they're served. Others are a nightmare. For instance, in India, you have to serve through a consulate. And based on what I've read, heard, and experienced, there's like one dude in this consulate for the entire country. And so your summons isn't going to get served for at least 18 months because it's just going to go through this bureaucratic process. So those are some of the challenges as it relates to U.S. contracts. So if I am or cross-border contract, so if I'm a U.S. company dealing with a foreign counterpart, what I want to make sure of is that U.S. law applies, that U.S. service rules apply, that we can override the Hague Convention, and that the other party consents to jurisdiction. Now, in my experience, most other parties are going to say, I don't want to agree to that. So what do? My recommendation is to find a country, an English-speaking country that has similar laws to the U.S. So you can say, hey, look, we'll get it outside of the United States, but we're still going to do something that, at least from a legal standpoint, we more or less know what we want to do. So what are those countries? I mean, I like to use Canada or the UK. UK is different, but it's close enough. And usually that'll get over the hump on certain contracts. And then the other thing you can do too is really beef up arbitration so that we can get outside the court system and try to settle our disputes through arbitration so we don't have to worry about service of process and other issues.
So, Stephen, as we wrap then, from a drafting standpoint of drafting these documents, what coordination should people be on the lookout for with respect to governing law, venue, jurisdiction, all of this, so that way it avoids future litigation over where or whose law is going to decide how is this disputed?
Well, if I'm a business owner, I don't want to spend money on attorneys, right? And so the thing that I want to do as a business owner is make sure that it's most favorable to me. I've probably got a lawyer that I know. And so I'm going to want to keep it in my state where I'm located and in my jurisdiction, meaning like my county, where I have local contacts, right? So if you are negotiating a contract that the other party is signing, then my recommendation would be keep it in your jurisdiction as much as possible. If you are receiving a contract from a counterparty that's doing exactly that, keeping it in their home jurisdiction, analyze what could go wrong in this contract, right? And if something goes wrong, what's the likelihood of me needing to retain counsel in that jurisdiction? And also, if something goes wrong, is there a material issue that would come up that would really change the game here? If the answer is no, then you can push back on it if you want. But if the answer is yes, then I would recommend that the parties have a discussion and figure out what they can do to move it forward. Again, arbitration might be a good mechanism to get around all of this stuff as far as venue. If you can agree to say, hey, look, if there's a dispute, we'll arbitrate it, and you can do it virtually and all sorts of other things. So that's how I would look at this. From when transactions are going good, it's not important. It's when the deal falls apart. That's when this is really important.
That's right. When it falls apart, that's when it's important. Stephen, thanks for the time, the insights, breaking this down for the audience. Appreciate it.
Have a good one.
That's it for today's episode of Litigation and Capital with Stephen Mirsky. To learn more about Stephen and the team and all the work that they do over at Mirsky Corporate Advisors, do me a favor, visit mirskycorporateadvisors.com. And one more favor, as always, hit like, hit subscribe, leave a review, comment, share it with somebody who needs to hear it. I'm Mike Leon. We'll see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.